Good afternoon, good evening, ladies and gentlemen. Welcome to today's SIAC Middle East webinar titled A Practical Guide to Emergency Arbitration and Interim Relief. In today's webinar, leading international arbitration practitioners and arbitrators from Singapore and the Middle East will discuss strategic considerations, tips, and techniques when applying for emergency arbitration, the enforceability of such measures, and the interplay between emergency arbitration and other legal mechanisms. I am so excited to introduce today's panelists to you. We have Mr. Ian Daddy, who is the Managing Partner at Dentons, Abu Dhabi, Ms. Claudia Al-Haj, Managing Partner at Rashid R. L. Marie Law Office, Ms. Sarah Koilat Aranjo, Partner at El Tamimi & Company, Mr. Avinash Pradhan, Partner at Raja & Tan Singapore, LLP. And due to unforeseen circumstances, Ms. Paula Bost will not be able to join us today, but we're pleased to welcome Mr. Mazin El Mardi, Senior Associate at Charles Russell Speechleys, LLP. The panel session will be moderated by Mr. Paul Sandersham, Partner at Clifford Chance. Please send your questions through the Q&A function, and our speakers will try their very best to address as many questions as possible as we have limited time. And I'll now hand the time over to Paul. Thank you.
Well, good afternoon, everyone, and thank you for joining us. We've got a really distinguished panel of speakers covering a very interesting topic and something we're seeing more and more of in this current environment where parties are seeking urgent, immediate, and relief in either before the courts or before tribunals in the matters they deal with. So I'd like to start off this evening first by introducing Avinash, who's going to kick off to speak about the overview of interim measures and emergency arbitrators under the SIAC rules. So Avinash, do you want to kick us off?
Sure. Thanks very much, Paul. Hello, everyone. It is truly a pleasure to be addressing you today. So my task is to give you a brief overview of interim measures under the SIAC rules. There is a lot to compress into the nutshell, but I will do my best. So I start with the question, and perhaps we could go to the next slide, Perry. I start with the question, what are interim measures? Now, these are orders directing a party to do or not to do something that have effect pending the final determination by the tribunal of the party's dispute on the merits. If we could turn to slide 3, the UNCITRAL model law, which I've reproduced in my slides, provides a useful working definition, but I think it's perhaps easiest to illustrate with some examples. So taking the first item 2A, maintain or restore the status quo pending determination of the dispute. I give an example of a shareholders dispute where the shareholders agreement contains an arbitration clause to which the company and shareholders are party. Now the company, under the effective control of the majority shareholder, seeks to pass resolutions which would have the effect of diluting the minority shareholder's stake. The minority considers this to be a breach of obligation or that it may give rise to some form of statutory relief for minority oppression. Now, an example of an interim measure in this context would be an injunction restraining the circulation of the resolutions for the dilution. Now, as to the second point, take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice. In the projects and infrastructure context, where an employer is threatening to call on a performance bond, for example. Now, say the contractor considers that the call is fraudulent. In these circumstances, interim relief may be an injunction restraining the call on the bond pending the determination on the merits of the underlying dispute. Now, as to a third example with respect to item C, this is perhaps where there is evidence that the defendant to a claim may dissipate its assets so as to render the enforcement of any award pointless. In those circumstances, you may be able to obtain an order freezing the assets of the defendant pending the determination of the dispute. Could we turn to slide 4, please? So what are the ways in which you can get an interim measure where the parties have agreed to arbitrate? Now, the key provision here is Rule 30 of the SIAC rules. Now, the first way in which you can get an interim measure is from the arbitral tribunal itself. The SIAC rules contain specific provision permitting the tribunal to grant interim relief And you can see that at Rule 30.1 of the rules. But a problem with this is that the constitution of a tribunal can take time, and a party may need relief urgently prior to the constitution of the tribunal. Now, this is where the provision in the rules for the SIAC Emergency Arbitrator, or what I'm going to call the EA, comes in. Now, that is what is being referred to at Rule 30.2. An EA is an individual appointed on short notice to decide urgent applications for interim relief prior to the constitution of the tribunal deciding the merits. The EA's decision is not binding in any way on the tribunal, and the EA does not go on to become a member of the arbitral tribunal that decides the merits. The EA also does not have any power to issue a final award. The relief that it grants is strictly interim. Now, the third option provided by the SIAC rules is with respect to going to a court of competent jurisdiction. And you can see that reflected at Rule 30.3. You can see, though, that once the tribunal is constituted, the SIAC rules permit a party to go to court only in exceptional circumstances. Could we go to the next slide, please? Now, the specifics of the EA procedure are to be found at Schedule 1 of the SIAC rules. I've summarized some of the key provisions of the schedule in my slides, and I will just highlight 4 points in particular. Now, the first is this: the process of applying for interim relief through the emergency arbitrator is kickstarted by a reasoned application directly to the SIAC, which should be copied to the parties. Now, second, the EA is generally appointed within 1 day of the application being filed with the SIAC. This is specifically provided for under paragraph 3 of the SIAC rules. If we could turn to the next slide, you can see that under paragraph 7 of the rules of Schedule 1, as soon as possible after his appointment, but in any event within 2 days of his appointment, the EA is to establish a schedule for consideration of the application. Now, the EA must provide the parties a reasonable opportunity to be heard, but there is flexibility. It doesn't necessarily require an oral hearing in person. The rules expressly allow for hearings to be by telephone or video conference, and indeed provide for the application to be determined on the basis of written submissions. If we could go to slide 9, you can see that paragraph 9 of Schedule 1 specifically provides that the EA is to make his interim order or award within 14 days from the date of his appointment, unless in exceptional circumstances the registrar extends the time. So in essence, the application will be disposed of just over 2 weeks from when it is filed. Now, these are outer limits. In practice, and depending on the urgency, an emergency arbitrator can be persuaded to issue his decision more quickly than that, provided that the urgency is sufficiently demonstrated. Now, I hope that illustrates the power of the emergency arbitrator procedure. Could we go to slide 11, please? Now, there are pros and cons with it, however. Now, the pros, the proceedings are confidential. You have predictability as to the timelines and greater assurance that the application will be dealt with timeously. Now, the tribunal may be more, or the arbitrator may be more sophisticated than the judges in the court you might otherwise have to go to, and have a better understanding of the parties' commercial playing field. There are no appeals, and therefore there is very little room for procedural wrangling. On the other hand, there may be concerns regarding enforceability. Now, while some jurisdictions recognize the enforceability of interim measures of foreign-seated arbitrations, including those issued by emergency arbitrators, this is by no means universal. However, the reality is that in most cases, emergency arbitrator orders are usually obeyed. And the reason for that is that a party that disobeys the order is at risk of being perceived negatively by the tribunal, and that in practice often proves to be an extremely powerful disincentive. I'd highlight 2 other issues. The first is that where the relief is in the nature of relief where telling the other side about the application itself creates risks, then the EA procedure isn't suitable. So, for example, where you want a freezing injunction and the bulk of the assets are extremely liquid funds and where the defendant lacks probity, in such an instance, you'd probably be better off in court, where you can make an ex parte application without notice. Second, where you need relief against persons who are not party to the arbitration agreement. The EA and indeed the tribunal has no power to bind a person who is not party to the arbitration agreement. So here too, you'd probably be better off in court. Now, I turn briefly to the test for the grant of interim measures. If I could go to slide 13, please. Now, the SIAC rules do not set out the test to be applied by the arbitrators in determining whether an order for interim relief is to be granted. There are, however, many useful sources of guidance, and the leading textbooks on international arbitration are usually treated as acceptable legal authority by most international arbitrators. Now, I've reproduced in the slide that you see before you the provisions of the UNCITRAL model law on the requirements for interim relief and when it should be granted. But I would suggest that, as a matter of practice, these are usually treated by tribunals as a guide rather than truly prescriptive. And if I may be permitted to generalize some of these requirements. Now, it'll usually be necessary for the applicant to show that it has some likelihood of succeeding in the case, but the degree of the likelihood that is likely to be considered is going to be dependent on the nature of the relief that is sought. The more intrusive or burdensome the relief, the higher the threshold that the tribunal is likely to require at this stage. At the same time, experienced arbitrators will know that they should not be determining disputed questions of fact on the evidence at this stage. The second point I'd highlight is that it is usually necessary to demonstrate why the matters cannot wait until the final award. If the application is said to be urgent, the urgency will need to be explained and supported. The third point that I'd highlight is that it may also be usually necessary to explain why an award of damages would not be adequate compensation for the harm complained of and that is sought to be prevented by the injunction. Ultimately, however, most tribunals are likely to take a pragmatic view and to view the question of whether the relief should be granted as one of balancing the competing interests of the parties, taking into account all the circumstances of the case. So I promised to give a brief overview, and I hope I have achieved that. And I look forward to the discussion with my fellow panelists and their perspectives. So with this, I'll hand you back to Paul. Thank you.
Thank you, Avinash, for that broad overview of emergency relief. Perhaps I could just raise a couple of points which come out of your presentation. You touched on one of the key tenets, and that's enforceability. And I guess the question that I suspect many of the audience would want to know is the effectiveness of an EA's order for interim relief. How confident is an applicant that the respondent will abide by an order made by an emergency arbitrator, for instance?
It's a very fair question. The answer that I alluded to when I was speaking, that ultimately the risk of a negative perception, that really is a strong incentive. And in my experience, quite a lot of the time, the party on the receiving end of the interim order from an emergency arbitrator is going to abide that ruling just because of the risk of it being perceived negatively by the tribunal that ultimately decides the dispute. So that is a very powerful stick, as it were, and perhaps a carrot to ensure that the party complies. However, at the end of the day, enforceability is going to be a key consideration in deciding whether to use the emergency arbitrator procedure in the first place. And it's something that has to be thought through extremely carefully in deciding whether it is the appropriate mechanism, because you may well, in considering the options, decide that that factor leads you to going to court in a particular jurisdiction instead.
Well, an applicant may not be persuaded by the good sense of the respondent. Are there jurisdictions or courts that would recognize and uphold, or enforce orders for interim relief by emergency arbitrators?
Yes, so you see, well, Singapore is a great example of a jurisdiction that does that. The International Arbitration Act was amended some years ago now to make that clear. Hong Kong is another example, as is Malaysia. India presents a jurisdiction with certain unique challenges. If it's a Indian-seated arbitration, then you're probably going to be okay, as we've seen with the recent litigation in relation to Amazon. But that, of course, remains pending determination by the Supreme Court. On the other hand, if you're looking at an arbitration that is seated outside India, then you've got perhaps serious problems. And that is one of the circumstances in which you wish to consider whether using the EA route is appropriate.
Right. you talked about the options available to an applicant in terms of seeking relief, and the two broad routes an applicant could take are seeking relief either from the emergency arbitrator or potentially the courts, whether that's the court of the seat or otherwise. You've talked about certain situations. Could you offer some practical examples as to when you would advise a client to go to an emergency arbitrator or to a court? And if it's a court, which court will you go to?
So I think using examples is probably the best way, because they perhaps illustrate the considerations that you might want to take into account. Ultimately, though, no case is alike. I think a freezing injunction is a particularly good example. So if, for example, you were concerned that the defendant was dissipating its assets, but the assets that you wanted to secure were in a particular jurisdiction where the efficacy of the order would really be enhanced by the ability to go to court straight away to freeze that asset, you may want to wish to consider bringing the injunction in that court. So that is perhaps one example. I think the location of assets is usually one of the key considerations. Of course, the ease of enforceability of the interim award is going to be a particularly important consideration in all this as well.
Thank you, Avinash. And with that, may I invite Sarah now, who's going to talk about interim measures in the context of the Middle East, and she'll also discuss some recent decisions in the DIFC court. So Sarah, would you like to take us through your presentation?
Thank you very much, Paul, and good morning, good afternoon, or good evening to the participants who join us today. So I'll be providing an overview on the availability of and the powers of the courts in the Middle East to order and interim measures, generally speaking, as part of their broader judicial powers. And then I'll be providing a couple of recent developments on the courts front, particularly Dubai International Financial Centers courts. And I will conclude with a recent practical example in a case in which I appeared as counsel, which shows sort of the intricacies and the challenges that parties could sometimes face with respect to the ultimate availability and then of interim measures. If we could please go to the next slide. And then the following one, please. So as Avinash has indicated, typically parties, whether they are currently engaged in arbitration proceedings or are prospectively to be engaged in arbitration proceedings, from a practical perspective, and obviously the current economic conjuncture has not necessarily eased out requests for interim measures, but typically there are a set of very much popular interim measures that are always sought after by parties, particularly, I guess, with respect to certain specific industry. And the construction industry is a very popular industry in which we often see applications for interim measures. And these can vary from, as we can see from the slide, as to freezing orders, security for costs, top payment orders relating to first demand bank guarantees, escrow accounts, and then lastly, counter guarantee, or what is often referred to as back-to-back guarantees. If we can please go to the next slide. So just at the outset, I would like to highlight that there are obviously very important strategic considerations to take into account at the step even preceding any dispute, which is how to consider devising your arbitration agreement as part of the overall drafting of an agreement. And typically, one should always be cautious about the relevance of, on one hand, the choice of the national applicable arbitration law, the lex arbitri, or the law of the seat that would govern the framework of the arbitration proceedings, as well as the choice of the applicable institutional rules in the event parties agree to institutional arbitrations, because both of these set of, on one hand, laws and then rules would obviously command the availability of interim relief. And so the often the availability of interim relief is commanded, but also the overall framework in which interim relief obviously is also granted, such as, for example, confidentiality considerations or any expertise with respect to the competent authority ultimately that's going to be asked or invited to issue interim relief are important and cardinal considerations to take into account when looking at devising the arbitration agreement at the very outset of the commercial relationship between the parties. If you can go please against the, for the second slide. And the reason for which, as I've said earlier, interim relief or interim measures generally available are quite of significance is because obviously they would end up in support of either an ongoing or a prospective arbitration proceedings and would help secure the outcome of a final award, mainly in view of the ultimate finality and enforceability of the arbitral award. As Avinash has indicated earlier, those are interim, which means ultimately that these are not final. And in this regard, the relevance of the choice of the seat and the application of the national law is, as I've said, quite important. And if we look, for example, at a jurisdiction like the United Arab Emirates, many of you might be familiar with the fact that the United Arab Emirates offers quite a rich judicial framework, in the sense that there are three judicial systems operating with it, mainly two under the main summa divisio of, on one hand, a civil law judicial system operating mainly in UAE mainland or onshore UAE, and then the common law judicial systems operating mainly in the offshore free zones, and which also carry a judicial functions. And I'm referring particularly to the Dubai International Financial Center in the Emirate of Dubai, and the Abu Dhabi Global Market in the Emirate and capital of the United Arab Emirates, Abu Dhabi. Now, if we look very briefly at the three sets of laws that govern arbitration proceedings, or the lex arbitri to be applied, for example, in a Dubai seat or a DIFC seat or in an ADGM seat, we can see that most of these laws provide for the capacity for the courts and the authority of the courts to order interim relief. And very importantly, I would also like to add that the reference as well to the laws of the seat is quite critical, in a sense that it would provide guidance as to the scope of such authority by the courts, but as well, most likely and most of the time, would identify the competent judge capable of issuing such interim relief. And it's very noteworthy to note that the recently issued UAE arbitration law, which came into effect in June 2018, provided a change with respect to the competent judge with regards to interim measures. And before the issuance of the new UAE Federal Arbitration Law, which is law number 6 of 2018, the competent judge with respect to interim relief and measures was the default judge under the general framework of the Civil Procedure Code, who was the summary judge of the court of first instance. And the novelty which has prevailed as a result of the enactment of the new federal arbitration law in the UAE is that a competent judge, who's the Chief Justice of the Court of Appeal, has been identified as the competent judge to issue relevant interim measures. And if we look very briefly at the available provisions under the three sets of laws, it's important to note that, for example, Article 18.2 of the UAE arbitration law provides that the arbitral tribunal, as well as the parties, have the power to approach the courts directly for interim measures. this is important to note because neither the DIFC arbitration law, for example, or the ADGM arbitration regulations grant such powers to arbitral tribunal. Likewise as well, we note that Article 24.2 of the DIFC arbitration law provides that a party that is compelled to approach the DIFC courts for an interim measure application would eventually be entitled to recover any legal costs and fees incurred as a result thereof. Equally, we note that neither the ADGM arbitration regulation or the UAE arbitration law provide for such ability to recover such costs. And as well, we note that the UAE arbitration law allows the arbitral tribunal to grant interim measures on its own initiative pursuant to Article 21, which we can see on the screen, and that neither the DIFC arbitration law nor the ADGM arbitration regulations grant the arbitral tribunal such powers. And so I go back to the point as to really the important strategic considerations that parties would have to consider as part of their agreement with regards to the applicable framework as to the procedure of the arbitration rules that will ultimately govern the arbitration proceedings. And we will see later on in the presentation a practical example where the differences in the provisions and the authority of the respective courts came into play. Going on, please, to the next slide. It's important to know that historically in the Middle East region, the respective arbitration laws as well, and we can see on the screen Egypt, Saudi, Qatar, and Jordan and Lebanon in the following screen, really did provide authority for the courts to issue interim measures in support of arbitration proceedings, whether these have been commenced or are about to prospectively be commenced. And we can see as well, just in the interest of time, I will not go into the details, and I know that my colleagues will be discussing some of these provisions in detail. But we can see as well that what's telling is obviously the identification of the competent judge who has the authority to issue interim measures, and ultimately the scope and pool of available of interim measures. However, historically, what has been interesting to note is that the enforceability of arbitral tribunal ordered interim measures in the Middle East have suffered from several challenges, and I'm talking particularly with respect to the effectiveness of these interim measures, because historically speaking in the region, and I'm talking about the Middle East region, national courts have been quite resistant with regards to the enforcement of tribunal ordered interim measures. And if we can go please to the following slide. And so up until very recently, and I'm talking about a major significant development which has occurred in the DIFC in the last few months, and I'm talking specifically about early 2020. Up until very recently in the UAE, enforcement of an arbitral tribunal ordered interim measure was extremely challenging. And it is worth noting that the Dubai International Financial Center, which, as I've said earlier, is an independent judicial free zone in which common law, English language, DIFC courts sit, have resulted in an order for enforcement of an arbitral tribunal ordered interim measure. And this is an extremely noteworthy development because, as I've said earlier, there has been extremely extraneous challenges with respect to the enforcement of arbitral tribunal interim measures, which on one hand were available theoretically under the framework of the national arbitration laws, but in practice, their enforceability was at stake. So the latest DIFC court judgments, as we can see, have actually filled the gap with respect to that dichotomy which existed on one hand between the available theoretical powers of the arbitral tribunal under the national arbitration laws, and then ultimate enforceability of such order by the courts. And we can see in case one, it's a case in which we were involved in, that in a DIFC-seated arbitration governed by the DIFC arbitration rules, an interim order was actually awarded by the arbitral tribunal, pretty much resulting in that the request for encashment of a bond be ordered to be stopped by the respondent. And obviously such an interim order was granted by the DIFC courts and ultimately complied with. As we can see on cases 2 and 3, the arbitration agreements did provide for the application of the DIFC arbitration law. However, what's interesting in these cases is that ultimately the arbitration was not necessarily commenced at the time, and that such orders were made in support of a prospective arbitration on the basis of an urgent ex parte application. Moving on just very briefly to the following slide. I would just like to close off by providing, in the interest of time, very brief remarks on this case study, which is relates to a dispute that has arisen from a contract between a contractor and an MEP subcontractor. The agreement provided that disputes shall be referred to arbitration, providing for an institutional arbitration whose rules provided for powers of the arbitral tribunal to order interim measures, but also that the seat be the DIFC, and as such the application of the DIFC arbitration law. There has been a call on the performance bond, and what's interesting in this case is that the call has took place in July 2018, which is almost a month after the new arbitration law in the UAE came into force. And what's interesting is to try and understand the battles that has taken place between the parties, both before the Dubai courts, onshore courts, but also as well before the arbitral tribunal and thereafter subsequent DIFC courts. And if we can please move on to the next slide and the last slide. As we can see, there has been several applications that were filed before the Dubai courts. Thereafter, there was an application as well with respect to an interim relief application before the arbitral tribunal as well. And what I would like just to close off on is to highlight that often the availability of relief in theory is set out clearly in the respective institutional rules, such as the SIAC rules, or even the national law governing the framework of the arbitration. However, ultimately, in terms of applicability from a practical perspective, and in terms of granting the orders and their respective enforceability, this is a very telling example in the case I've just mentioned, which unfortunately, in the interest of time, I will not delve into much detail into it. But as we can see from the screen, there has been definitely successive actions in trying to uphold, on one hand, orders made that were probably not necessarily warranted in terms of competence of such a court, at least from a territorial or rules application perspective. And on the other hand, with respect to the securing and the preservation of the rights of the party. I will close off on this point, Paul, and hand it back over to you just in the interest of time.
Thank you, Sarah, for that overview of and it's encouraging to hear that there are many routes for obtaining interim relief across the Middle East, whether in the courts or before an arbitral tribunal. Perhaps one thing I wanted to explore with you, and it's something that arose out of Avinash's presentation, where he talked about the test of obtaining interim relief, and he was looking at it from the perspective of the common law and under the SIAC rules. Would you be able to give some broad guidance in terms of what a court or tribunal would be expected to see from an applicant before it granted interim relief?
Yeah, sure, Paul. I mean, obviously, I mean, each jurisdiction would tend to have certain nuances, right? But just generally speaking, and if we look at the richness in terms of judicial systems, and I'm talking specifically about the UAE and Qatar, because both the UAE and Qatar offer more or less of a hybrid judicial system, in the sense that you would have on one hand the main onshore system, which is derived from civil law tradition, with certain inspirations as well from Islamic law traditions and principles. And then you would have the common law sort of enclaves or judicial enclaves, which are present in the DIFC, the ADGM, and then in Qatar, the Qatar Financial Center, the QFC courts. And so by and large, what's important to note is that subject to the nuances, obviously, for each jurisdiction, and the manner, I think, more importantly, in which these are applied by the courts as well, because there is always, from a practical perspective, always interesting to note the dichotomy between, on one hand, the theoretical framework, and then on the application and receptivity of such standards by the courts as well. But by and large, I think most of the time, applicants are only minded to consider the standard of urgency. And I think this is what comes really to mind. And I think when you speak to users, and I'm talking also as well, you know, with clients most of the time, I think the perception is always that, you know, the standard should be the element of urgency. And what I would like just to clarify is that urgency can obviously be one factor, but I think ultimately, and more, and I can speak as well as with respect to my experience as well with the DIFC courts and more generally as well the UAE courts, the onshore UAE courts, is more and more the standard that's applicable and provided for is the presence of an irreparable harm. And this is extremely important in practice. The presence of irreparable harm, and obviously there has been many judicial interpretation as to what irreparable harm is. But generally speaking, and by and large, irreparable harm is to show an evidence to the competent judge before which you're appearing that should the proceedings continue, the arbitration proceedings continue, and relief is not granted, what will ultimately be ordered in the final award will not be able to be recovered or recouped because of lack of an emergency, of an interim relief. So obviously, you would have to evidence that the granting of an interim relief is to secure your ultimate recoverability of the award, absent which any harm you as a party would have suffered would not be capable of any reparation or compensation.
Great, thank you, Sarah. There's some questions, but I'll come back to them later. Perhaps now we'll move on to Ian, who's going to give us a broad overview on interim measures under the DIAC and the ADCAC rules, and discuss the relationship between the national courts and tribunals in the context of interim relief. Ian?
Good. Well, thank you, Paul, and good morning and good afternoon to all our attendees, depending on where in the world you are. I'm very grateful to Avinash and Sarah for explaining many of the underlying principles of interim relief and emergency arbitrators so eloquently and succinctly, which makes my job an awful lot easier when I come to talk about the sort of clash that we're seeing between emergency arbitrators and the UAE onshore courts. Now, as Sarah kindly explained, when we refer to onshore, we're talking about the jurisdiction of the United Arab Emirates, excluding the Dubai International Financial Center and excluding the Abu Dhabi Global Market. So we're not talking about the two offshore sort of common law style separate jurisdictions. We're talking about the onshore courts. Now, if we could move to the next slide, please. So let's have a quick look at the regulatory framework again. And I'm again very grateful to Sarah for outlining many of the principles behind the federal arbitration law, which was introduced fairly recently. Before that, there was a lot of uncertainty over the extent to which the onshore courts in the UAE would support interim orders and provisional awards issued by arbitration tribunals seated in the UAE. I'm glad to say much of it was clarified by the new law. Article 18, as Sarah again mentioned, outlines some of the court's powers in respect of interim measures, and the provisions entitled general jurisdiction to consider arbitral measures. And this talks about how the courts can order interim measures at the request of the tribunal or at the request of a party. And Article 21 goes on to set out in some detail the powers of arbitral tribunals seated in the UAE to order interim or conservatory measures. Now, it's also worth mentioning here two of the more popular arbitral institutions in the UAE. The first is the Abu Dhabi Commercial Conciliation and Arbitration Centre, and their rules provide for provisional and precautionary measures at Article 25, but they really don't go into very much detail as to what those might be. And likewise, the Dubai International Arbitration Centre at Article 31 also deals with interim and conservatory measures of protection, but again, not going into very much detail as to what those might be. However, this isn't necessarily too problematic, because Article 21 of the Federal Arbitration Law does provide a bit more detail as to what those might be. And note, however, neither of those two sets of rules has any emergency arbitration procedures, and partly for that reason, other sets of rules are very popular here in onshore UAE. We see a lot of LCIA rules, ICC rules, and of course SIAC rules. So can we have the next slide, please? So what I wanted to talk about briefly today is, if you like, a hypothetical scenario. And when I say hypothetical, of course it is related to real life cases, but for the reasons of confidentiality, I don't want to provide too many details. So I've merged a couple of different disputes that I've been working on into one hypothetical scenario, just so we can see, by way of illustration, what the problems that are faced when there are conflicting decisions between the local courts and arbitral tribunals. So imagine this very popular and common set of circumstances. You have an employer on a construction contract, on a construction project, who enters into a construction contract with a contractor. And a provision of that contract is that the contractor must provide an on-demand bond. And typically, as we all know, there will be a performance bond, quite often of an amount approximately 10% of the contract sum, and maybe even an advance payment bond. Other bonds, you get a retention bonds and so forth. But generally speaking, these are all on-demand bonds. They are supported by provisions in the UAE Civil Code, saying that if it's an on-demand bond, the bank has to pay out if you like, on demand. There can be no excuses. And in order to procure these bonds, the contractor will enter into a facility agreement with its bank, under which the bank will agree to provide the bond under certain conditions. And then it issues the bond to the employer. So we've got a sort of three-way scenario between three parties under three contracts. Now imagine then that the unfortunate situation arises that the employer then issues a demand on the performance bonds and asks for the money from the bank. Now, at this point in the project, the contractor obviously wants to take steps to stop this. So the first thing he will do normally is apply to the courts, the local courts, to stop the bond liquidation. And Sarah kindly touched on some of the reasons why the courts might decide to not or to ask the bond to be stopped. Issues of fraud. Sometimes there might be a flight risk where the courts think the employer is just going to grab the money and disappear. And sometimes the courts have been reluctant to liquidate or allow the liquidation of on-demand bonds where the construction project is finished or nearly finished. But there can be many reasons. So imagine in our scenario, the contractors applied to the courts to stop the bond liquidation, and the courts have looked at the evidence and decided no, this is an on-demand bond. We see no reason to prevent the liquidation. So then the contractor's in a difficult position. The court has already decided on the issue, so he looks for other options. And the first option he'll look at is under the construction contract. He sees, for example, an arbitration provision referring the disputes under the agreement to, say, SIAC rules. And so he realizes he's got an alternative avenue of pursuing an interim order from an emergency arbitrator under the construction contract. So a very short notice, an emergency arbitrator is appointed, and that emergency arbitrator looks at the evidence and decides, yes, let's grant an interim order, and we'll decide who owes what to whom at the end of the dispute. Until then, the employer is not permitted to pursue the liquidation of the on-demand bond, and the contractor must maintain the bonds until the final award, at which point the arbitrator in the main proceedings will decide who owes what to who and what should be done. So in our scenario, imagine that the emergency arbitrator does issue the interim order. And typically what we see in this region is that emergency arbitrators know that provisional awards are slightly better regarded in the local courts than interim orders. So they also issue a provisional award on the same terms, broadly speaking, as the interim order. Of course, the contractor is also wary that that order does not, or that provisional award does not bind the bank. The bank is not a party to that arbitration agreement. And the bank will be probably aware by now that the courts have decided that the liquidation of the bond should not be stopped in the application previously made by the contractor. So the contractor just needs to look for other options as well to avoid the bank paying out. So the contractor looks at the facility agreement he has with the bank, and again, in our hypothetical scenario, the contractor spots a SIAC arbitration provision, and realizes again that he can go to an emergency arbitrator and perhaps seek an interim order preventing the bank from making the payout under the bonds. So off he goes to the emergency arbitrator, and again gets that interim order and subsequently a provisional award. So the employer is watching this from the sidelines and sees, well, we've now got 2 provisional awards issued by emergency arbitrators that conflict with the order previously issued by the courts to stop the not to stop the bond liquidation. So the employer decides to apply to the local courts for a payment order, and in the UAE, a payment order is a fast track process by which a party who is pursuing an undisputed debt following notice can approach the courts and get a payment order from the courts ordering the payment to be made with an award of interest subject to appeal. So the employer gets to the courts and obtains the payment order, and the contractor appeals the payment order, and the courts say no, we're standing by our original decision that the bond must be paid. And so now you've got 2 different court decisions supporting the liquidation of the bond, and 2 emergency arbitrator provisional awards purportedly saying that the bond amount should not be paid. So imagine if you're the bank, you're faced with these different conflicting orders. What do you do? Well, the story isn't finished yet, because of course the employer's got further options. So the employer can apply to the courts to have the interim order under the construction contract invalidated to the extent that it conflicts with a previous order of the court. And in this regard, it's useful to refer back to Article 18 of the UAE Federal Arbitration Law. And you'll recall that Sarah mentioned this contains some of the court's powers in respect of interim awards. But one of those provisions essentially says that only the courts can overturn an interim order or a decision in relation to an interim order that the courts have issued. So at that point, that the courts can state that the interim order from the emergency arbitrator in the construction under the construction contract dispute is not valid, and that will then put the contractor in a much more difficult position. So still, as the bank, you have a problem. You've still got an emergency arbitrator interim order hanging over you under the facility agreement. So that I think is an illustration of the confusion and the conflicts that you see between the local courts and emergency arbitrators in the scenario where an employer seeks to liquidate a bond which is contested by the contractor. And what I would do, I think, is just finish on 2 observations. And the first is that in my experience and perhaps it's different for my colleagues, but in my experience that the courts are taking a slightly more robust approach on the enforcement of demands to liquidate performance bonds. But ultimately, where there is a conflict between emergency arbitrators, provisional awards, and the local courts, then it's really not a battle that the emergency arbitrators are likely to win in the long term. And I think the second observation that I'll finish by saying is that it does appear to me that many emergency arbitrators simply take a very cautious approach to these kinds of interim orders. A lot of these emergency arbitrators are appointed from jurisdictions outside the UAE. They may have had some involvement in cases in the UAE, but perhaps they don't have a lot of in-depth experience in this jurisdiction. And for that reason, they're slightly nervous of rejecting these applications to not pay out under performance bonds, and I'd much prefer to take the cautious approach and grant the application and let the parties fight it out in the local courts or in the arbitration. So with that, I'll hand back to Paul.
Yeah, thank you, Ian, for highlighting to us some of the risk of conflicting decisions between the courts and tribunals. In the interest of time, I'll come back to questions, but perhaps we'll move now from the UAE to Bahrain and Saudi, where we'll have Mazin give us an overview of the situation there, and he'll speak also on some cases involving performance bonds. Mazin?
Thanks. Thank you, Paul. Hi, everyone. Thank you for attending. I will just share my screen quickly. And I will try to be as concise as possible in the interest of time. Paul, can you just confirm you can see that screen, yeah?
Yep, can see it, thanks.
Okay, great. Okay, so we'll jump right into it. I'm covering Bahrain and the Kingdom of Saudi Arabia. We're looking at measures for interim relief and emergency arbitration. Okay, as many of you may be aware, Bahrain introduced or it fully adopted the UNCITRAL model law on international commercial arbitration as its arbitration law back in 2015. It repealed the arbitration chapter in the civil transactions law, which is the civil code. I believe Avinash has already gone through some of the provisions of the UNCITRAL model law, the key provisions which interim measures and emergency arbitration should be considered against, namely Article 17A. I will not repeat those as he covered them quite well. The objectives here for any client we deal with in the context of emergency measures are pretty much universal. We're looking for the preservation of assets out of which a subsequent award may be satisfied, preservation of evidence that may be critical for the determination of a claim, and the prevention of harmful acts. So the types of relief that are available under the UNCITRAL model law and applicable in Bahrain are injunction orders, freezing orders, precautionary attachment of assets, travel bans, and in some instances before the courts, they may issue attachments of an asset in the hands of a third party. I'm going to go straight into the meat of it, which is what clients are interested in, is what are the procedures available to them to secure interim relief, either prior to the commencement of arbitral proceedings or after the commencement. I'll start with the courts because I believe that's the strongest place to hit a counterparty with an interim relief or an interim measure. The procedures here, more often than not, an interim measure, when it's sought by a party in the context of a dispute, it requires urgent relief. That means that you need to make an application before the Urgent Matters Court, or the Court of Urgent Matters here in Bahrain. That has jurisdiction to hear applications for interim relief. Those applications can be made ex parte, which can give you an advantage of not necessarily warning your counterparty. The court will have discretion, or the summary judge will have discretion as to whether the other party should be given an opportunity to respond or perhaps be summoned. If it's satisfied, if the summary judge is satisfied with the evidence submitted and the reasoning, he may issue a decision within 2 to 3 days. I've had experiences where it's taken a little bit longer than that. Sometimes it's taken up to a week to get a decision, which in the context of the situation that Ian described, where you're trying to prevent, for example, the liquidation of a bond, is not helpful. You need the decision to be as quick as possible. That said, the advantages of seeking relief from the court as opposed to referring an application to the tribunal or perhaps an emergency arbitrator is that you have this immediate enforceability. If a favorable award is granted, the consequences obviously of non-compliance are severe. When it comes to court orders, you don't want to find yourself in contempt of a court order. The court has the power to compel third parties if it so chooses. And the fact that you can make this ex parte application means that you may be able to preempt actions that you're anticipating from your counterparty. And generally you find with summary judgments or summary court proceedings is there's a flexibility. The judge, he may hear your application and call you on the same day to appear before him and give an explanation, give a clarification. He may choose to summon the other party within 24 hours. He may ask both of you to attend at the same time and hear evidence. These practical advantages help him expedite the process. And the objective being obviously that you'll have a decision within the shortest time possible. I won't repeat the requirements that Avinash alluded to for granting or the conditions to be satisfied for an interim measure to be granted, but I will say that from experience, judges, particularly the ones before the Urgent Matters Court here in Bahrain, they apply very much, their approach is very much aligned with the provisions of the Universal Trial Model Law. Generally, they'll look to the degree of urgency, which Sarah was discussing. They'll look to why this application needs to be granted now and I cannot wait for a final award. They'll look to the legitimacy of the original claim, which is the reasonable possibility of success, prima facie, obviously, just on the face of it. They'll consider whether there's any flight risks, and it won't be enough to indicate that your counterparty is a foreign entity when you're considering flight risks. You must show, firm evidence that the party is that there's a very particular reason why that party is a flight risk, not just where it's domiciled or the nationality of the counterparty. And more often than not, we'll see decisions where courts are reluctant to enforce or to order interim measures in the context of an ongoing arbitration. Is they'll ask whether the termination must be made on the merits in order to justify that order. The summary judge does not have jurisdiction to make a determination on the merits. He doesn't have jurisdiction to look in depth into the case. And for that reason, if he feels that your application requires him to look deeper into the facts and make his own determinations, he will reject that application 9 times out of 10. Moving on to the principal arbitration center in Bahrain, which is the Bahrain Chamber for Dispute Resolution, established back in 2009 in partnership with the American Arbitration Association. The rules of arbitration under the BCDR provide for interim measures under Article 26. Notification must be given to the other party. The parties are given equal opportunity to plead their case. That can be an issue sometimes when there's an issue of time. For example, in the context of a potential liquidation of the bond, the tribunal will have the discretion to allocate costs between the parties, and he may condition an award for interim measures on the provision of security for costs of the application. The BCDR rules also provides for emergency arbitration. Emergency measures can be taken. Online applications are encouraged, as with most applications now that we're submitting to court. In that application, obviously, you'll set out the nature and circumstances of the application, the reasoning behind it, the legal basis, and you must obviously notify the other party of that application. The emergency arbitration fee is quite high. It's $35,000 at the BCDR. $10,000 will go as a non-refundable fixed fee to the chamber, and $25,000 will be reserved for the emergency arbitrator fee. That is refundable if the chamber decides to reject your application to commence emergency arbitration. If you want to challenge the emergency arbitrator for a reason of impartiality or some reason that you feel he's not qualified to make a decision, that must be made within 2 days of his nomination, and the chamber will make a decision on that challenge within a further 2 days. Ultimately, the emergency arbitrator is required to give a decision within 15 days of his appointment, unless obviously the parties agree otherwise to extend that period. It may be extended. Before I move on to quickly summarize the situation in Saudi Arabia, I'll give you a quick case study or a real life example of how emergency arbitration proceedings can be difficult for clients in terms of obtaining or achieving the objective you want practically. We, or on behalf of the client, it was a subcontractor situation. We were representing the subcontractor. The bank notified the subcontractor of a call on their bond after we had submitted our request for arbitration to commence proceedings. It was an ICC arbitration. And so we thought, what are the options here to try and prevent the liquidation of the bond? And we decided to exercise the emergency arbitration procedures. We initiated that prior to, obviously, constitution of the arbitral tribunal. Now, the emergency arbitrator was appointed by the ICC within 2 days. And after our initial submissions, the emergency arbitrator, he issued a temporary order pending his final award for the other party to withdraw its call on the bond. Now, obviously, it didn't have the power to compel the bank to freeze the bond. It had issued a direction to the respondent in this case. In any event, the bank had insisted that the only way it would be able to, resist liquidation of the bond would be by way of a court order. And even though it had sight of the temporary order of the emergency arbitrator, which we provided, they weren't interested. So eventually, the final order by the emergency arbitrator was issued within a week or so, after a brief round cycle of submissions between the parties. And in that order, the emergency arbitrator had explained that the fulfillment of the temporary order was rendered impossible as a result of the conduct of the respondent, his non-compliance, essentially. And for that reason, all he really could do was issue an order as to the costs of the emergency arbitration, which he did. He awarded all costs in our favor. So he awarded the cost to be paid by the respondent. The respondent had then, the contractor accepted liability for the costs as per the order, and it reserved to set it off essentially against whatever amounts would be, it would be ordered to pay in the final award, which we accepted. Now, a local court may have some reluctancy in enforcing an interim order, as Ian correctly mentioned. We've seen it before where there is some hesitancy, primarily because, one, they have to be satisfied that there's an absolute urgency in this matter, and it can't wait until the final award. And two, they're very conscious of the fact that there's an underlying arbitration that's still underway, that's ongoing, and no final determinations have been made with respect to the rights and entitlements of the parties. And for that reason, makes it difficult for them to issue an order with confidence that it won't cause harm to the party against which it's made. So we see that there are some practical difficulties with the emergency arbitration. It was very effective in terms of the process and very expeditious. However, the result, it all came down to enforceability. What's a final order, a favorable final order without enforceability? It's not worth very much. Well, in this case, the tribunal who had jurisdiction to hear the merits of the case considered the conduct of the other party in not complying with the temporary order, and it issued costs in our favor, and it cited that the conduct was not acceptable. So that's a real life example of how emergency arbitration proceedings can be tricky to navigate. I'll quickly just give you a summary of the situation in the Kingdom of Saudi Arabia. They've made significant progress since 2012, generally in the field of alternative dispute resolution. In 2012, they had the introduction of the Saudi arbitration law, as well as the Saudi enforcement law. These are two major leaps in terms of the legislature in Saudi Arabia surrounding arbitration, as well as for interim measures and emergency arbitration. The Saudi Center for Commercial Arbitration was established in 2014. The executive regulation for arbitration law, which basically provided clarifications as to the 2012 Saudi arbitration law, was released in 2017. In terms of interim measures, Article 22, which Sarah correctly mentioned, of the Saudi arbitration law allows for a competent court to order provisional or precautionary measures upon request of either party prior to the appointment of the tribunal. If the tribunal is appointed, then it's the tribunal that may submit such a request to the court. In this case, the competent court is the Court of Appeal. They have supervisory roles in terms of arbitrations. Applications for annulment or setting aside an arbitral award would be heard also before the Court of Appeal. And finally, looking closer at the Saudi Commercial Center for Arbitration, okay, it's a non-governmental body, it's independent. Its roster includes 300 plus arbitrators, the majority of which are non-Saudi. With respect to emergency arbitrator proceedings, Appendix 3 sets out the criteria. A party seeking emergency relief under Article 6 may file a reasoned request for emergency relief with the administrator, and he must obviously notify the other party of that application. The administrator will appoint an emergency arbitrator within 1 business day, and within 2 business days of his appointment, the emergency arbitrator will establish the procedural timetable, and the order should be made no later than 14 days from the date of filing. And I think, yeah, that'll take us to the end. Thank you.
Thank you, Mazin. And finally, we move on to Qatar. Claudia.
Yes, good morning, everybody. Thank you for having me. I'll be mainly covering Qatar. And 1 second, so I share my presentation. Basically, I think that the general rules and principles have already been covered by the other speakers when it comes to interim and temporary measures. It's almost the same under Qatari laws, but I will cover this, and then I will move on to the competence of courts and arbitral tribunals and address the recent temporary measures taken by the courts and arbitral tribunals. Now, here I would like to highlight what Sarah has said before, that the strategic considerations and procedures are very important when deciding on a case in hand. So, and especially when choosing an arbitration clause and the seat of arbitration. Qatar just like any other civil jurisdiction, have a variety of interim orders and summary judgments that can be issued. These are examples. A receivership, it could be an inspection by the court or by the tribunal, court-appointed experts, preventative attachment orders on movable assets, ban of travel, attachment order in the hands of third parties, and attachment of shares, debentures, dividends, and stocks. These are under the civil and commercial procedural law in Qatar. For instance, just to give an example on receivership, this is not in Qatar, this is an example that happened in Lebanon, outside the construction world. We had a tenant who was a producer and a director of plays, theatrical plays, who decided overnight to leave the premises, the theater that he was renting, and to move to another theater. The following day, we applied for the appointment of a receiver to receive all the income of the play. So the receiver went every single night and stood next to the cashier and collected the funds at the end of the evening. This was against the outstanding rent that was due. So this is a kind of an urgent matter that was handled by the judge of urgent matters. Moving on, under the arbitration law, and this is a novelty here that was introduced by the arbitration law of 2017. The law allows the arbitrator to take temporary measures and to issue temporary measures and temporary awards as the nature of the dispute may require. And this is for the purposes of avoiding irreparable damage. And here are some of the examples which have already been covered by the other speakers. The arbitral tribunal also has the right to appoint experts to provide a report on certain matters as specified by the arbitral tribunal. The tribunal also has the right to request the assistance of the competent courts in obtaining evidence related to disputes, including technical expertise and or examination of evidence. Now, regarding the courts, the competent courts and the arbitral tribunals, here we have the summary judge of the national courts. We have also the courts that would look into the substantive cases, and this is based on the principle of who can do more can do less. So they can take the role of a summary judge if they are looking into a dispute before them. And the QFC courts, which unlike Dubai, the DIFC, they are an onshore courts and not offshore courts. So the QFC courts are onshore courts who have also the powers and the competence to take similar measures. Now, when it comes to arbitration, and this is here the novelty, the law has granted the arbitral tribunal the right to order the enforcement of the order or award. The law has given the powers to the arbitral tribunal to request the competent judge to order the enforcement of the order or award issued by the arbitral tribunal or any part of it. And this is done according to the law here by a straightforward application with a permission from the arbitral tribunal. Now, I am not sure if this has been tested in Qatar. I am not aware of any precedents, but at least we have the legal provisions. We also have the enforcement judge courts as defined by the arbitral law. And the other competent court is the enforcement judge of the QFC court, which again is an onshore court. In addition to the courts, the arbitral tribunal also, the arbitration law also accepts, of course, institutional arbitration. And I'm here referring to a few of them. Of course, there are others. the SIAC rules, the KICA rules, and the ICC rules, which allow for interim and conservatory measures and emergency relief. So if parties choose to go to an institution, meaning they have accepted to abide by the rules of these institutions. Here, addressing the recent temporary measures taken by the courts or arbitral tribunals, well, as in other jurisdictions, the parties can request the appointment of experts in status quo lawsuits. To give an example, if a contractor is terminated and has to immediately leave the site, they can ask for the status quo, for the judge of urgent matters by filing a status quo lawsuit to appoint experts to go and check, for instance, let's say the progress of works, the materials on site, the situation of the site, depending on what the dispute is about. And this could be done before having a tribunal appointed, which usually takes time. Now, the issue here in Qatar is that the judge of urgent matters, when it comes to status quo lawsuits, it follows the procedure of a normal lawsuit, although postponement of the hearings is much less than what it takes in usual in substantive lawsuits. So it could be from 1 week to another, but again, it takes time if it's an urgent situation. Although the civil and procedural law does provide that in case of an emergency, the parties can go to the house of the judge to have an order issued. Again, here we address the ordering of the on-demand bonds. In this particular case, we have seen in Qatar at the early stages of the pandemic, it appeared as if there was a systematic orders issued to stop the liquidation of the bonds, regardless of the circumstances of the cases. And our law office have seen quite a few. Now, to give an example, one party has filed to obtain an order to stay a cashing of a bond, an on-demand bond. And when we saw the papers here, they had alleged that there is an ICC arbitration. However, when we looked at the claims filed, they did not pertain to any bond. So when we filed a grievance, eventually we obtained a judgment to annul the order that was issued for stopping the cashing of the bonds. In other cases, we've seen, we've obtained, for instance, an order to stop the liquidation of the bond. By the time it arrived to the bank had already liquidated the bond. So we went to obtain another interim measure, which is to seize the account of the counterparty who had unlawfully cashed the bond. And we did obtain a favorable order, which was also notified to the banks to seize the accounts of the counterparty. So this was a subsequent action when the first order, although was successful, however, the bank had already paid the bond. And this is here the case I'm referring to, 2484. There are also the other attachment orders which are to seize, and these are all conservatory measures, to seize in the hands of a third party the movable assets against debtors when the creditor have executive deeds or existing debts. And this is the famous Article 702 in the Civil Code that a lot of contractor and subcontractors rely on. However, this also has to follow a certain procedure. It's not automatically done. There are also the ban of travel and, as I've said, the appointment of receivers. Now, when it comes to arbitral tribunal, and as my colleagues have previously mentioned, it's also on a case-by-case basis, because depending on the tribunal and how cautious they are in in accepting similar orders, or they prefer that the parties go to the state courts to obtain them. We have seen in cases where the arbitral tribunal would order the parties to refrain, for instance, from cashing the bond and instead renewing it. And here, as Avinash mentioned, usually the parties would abide by the order just for the sake of the continuity of the proceeding and how they will be perceived by the tribunal. We've also seen arbitral tribunal appointing experts in certain situations. And another case is where the tribunal have ordered a party to pay its share of the costs when it is likely to compromise the other party's ability to proceed with arbitration. These are cases we have seen in Qatar. That's it in a nutshell, and I'll be happy to answer any questions, and thank you.
Thank you, Claudia, and thank you all the panelists. I appreciate that we are running short of time, but we have a couple of questions which perhaps we could discuss now among the panelists. And the first one says, what extent is it admissible to apply an interim measure when the arbitration clause mandates a phase of negotiations prior to initiation of the arbitration request, a phase that might last up to 90 days? Okay, a good question, something that commonly arises where if you have an arbitration agreement which specifies some mandatory pre-step before you can start proceedings, does that on its own act as a bar to seeking interim relief? Perhaps I could start from outside of the world. Perhaps Avinash, do you want to comment on that?
Sure, thanks, Paul. I think it's an excellent question. I suppose the prior question is, by what system of law and by what set of rules do you answer the question? And you'll need to consider it from the perspective of the law of the arbitration agreement, the law of the seat, potentially, as well as potentially from the rules of court that offer the alternative to the arbitral or the arbitral institution-based relief that you might otherwise seek. Having said all that, though, I think as a matter of principle, one of the arguments you might deploy to say that you would still be able to avail yourself of, for example, the provisions of the SIAC rules with respect to the emergency arbitrator is the fact that the parties, by consenting to the institutional rules, can be taken to have consented as well to the ability to grant relief in urgent or cases where it's exceptionally required through the mechanism of the emergency arbitrator.
Sarah, what do you think from your experience?
Thanks, Paul. I mean, I would concur with what Avinash just said, but also I would add that parties, just generally speaking, and particularly in the Middle East region where it's a predominant civil jurisdiction, there is a heightened element with respect to the party's duty to act in good faith. And and accordingly, in circumstances where there's definitely a high risk of a party's action during the escalation mechanism, that would result obviously in a situation that would cause unsurmountable and ultimately irreparable harm to a party, then such a party should not be prevented from seeking interim relief. So it's very important to note that ultimately the prevailing predominant view in the Middle East jurisdictions is that pre-escalation agreed mechanisms are mandatory and as such should be abided by. However, this should not prevent a party from seeking to safeguard and preserve its interest during this period, particularly in circumstances where the responding party could take advantage of such a period in order to dissipate assets. So ultimately speaking, there is no really any clash or contradiction. But again, we go back to the basics, which is what do the agreed rules say as well, ultimately. And we also go back to the other basics, which is what does the regulatory or procedural framework as provided for under the applicable national laws provide for.
Thank you. The next question is actually more comment, and it relates to the tests that some of the panelists were discussing earlier on. And the question is there a reason why institutional rules do not prescribe the thresholds for issuance of emergency relief? Although the comment also suggested that some institutions, for instance, Akika in Australia, does state the test to be applied. And perhaps, Ian, you could help us on this one, because you talked about some of the rules in the UAE. Perhaps should they specify the tests or should they not?
Okay, well I think my own preference, and if I was drafting the rules, this would be the approach I would take, is not to specify the tests. And the reason for that is the kind of circumstances that arise are so varied and in many respects unexpected, that to try to draft something which would encompass all eventualities would almost be a fruitless task. So that's the reason I would give, and you know, I'm very much in favour of setting out the principles, but not the detail.
Claudia, what do you think? I mean, from a Qatari perspective, would it assist parties if they knew what the sort of hurdles that he needed to cross before they even made an application for interim relief? Or would you agree with Ian that it's better to keep it general because it really depends on the facts of the case?
Well, actually, I think based on our individual experience, you can't imagine the various cases we see, and even if it's, let's say, under the same topic. But and again, these are institutional rules that should apply in various jurisdictions. So I don't think that you can be very specific if you want them to be international and applied across various jurisdictions. Otherwise, you will be limiting, because if it contradicts a public order in a certain country, this means you've lost all your possible cases in that particular jurisdiction. I would like to go back to the question before. For instance, the Qatari law grants the tribunal the power to take interim measures and precautionary measures, provided that the parties do not agree otherwise. So meaning, if in an arbitration clause you've already put whether it has a negotiation phase or not, if you mention that the tribunal has no powers to take similar orders or awards, then the tribunal will not be able to do it. And if you decide to do so, and let's say include it in the terms of reference, then they are capable of doing it. So again, it depends, and this is what was mentioned before, when the strategic considerations and procedures you choose when you draft an arbitration clause, and where will it lead? And in this particular jurisdiction, what's going to happen? And is it easy to enforce them or not? So I think there are a lot of criteria to be taken into consideration.
Thank you, Claudia. And Mazin, any final comments from any of those questions that you'd like to respond to? You're on mute.
Sorry, the classic mute. Yeah, I agree with everything that's been said. With regards to interim measures, the first question I found particularly interesting. Anyone who practices litigation in this region, the GCC, will know that you can file an application requesting an interim relief, an injunction order, for example, prior to commencing arbitral proceedings. The summary judge will require that you bring proceedings within 1 week of the date of your application. Now, if you commence proceedings for the underlying rights and entitlements, if you fail to bring the case within a week, you'll have the interim relief will cease. So he may grant it to you for a week, conditioned on the president that you'll bring an action within 1 week. If you fail to bring that action, either it's a referral to arbitration or commencement of whatever procedures you've agreed for dispute resolution, that interim relief will cease to have effect. Now, where you don't have jurisdiction, or the tribunal doesn't have jurisdiction to hear a dispute because the preconditions for commencing arbitration, for example, amicable settlement discussions, have not been adhered to by the parties, then it becomes a question. Does that prevent the the summary judge from issuing an order for interim relief. Not in practice it may, but as per the legislation it does not. He's not prevented from issuing an order.
Okay. Well, thank you, Mazin. I think we've run short of time, and I'm really grateful again for this wonderful panel who's given us a really good overview of interim relief across the Middle East and including in Singapore. So thank you everyone for joining us this afternoon or morning, wherever you may be. And thank you to SIAC for organizing this event and inviting us. Perry, do you have any final logistics or announcements you need to make?
None at all, Paul. I just wanted to thank you and thank all our panelists for joining us today, and to all our listeners as well and viewers. We are so happy to have all of you on today. Thank you very much, and have a wonderful evening, morning, afternoon, wherever you may be. Stay safe.
Thank you. Bye-bye, everyone.
Thank you. Bye.
Bye.
Thank you very much, everyone. Bye-bye.
Bye.
Thanks, everyone.